to this special episode of my Aletheia Dialogues with Whistleblowers, a discourse that's emerged out of an informal organic gathering and connection of people who are called whistleblowers because of their testimony to the Zondo Commission. And I have been filming interviews with them, those who have written their books, those who have sought to make more public, beyond just what the Commission said, the deeper truths of what was happening. That's organically evolved into a very encouraging grouping of people in solidarity with each other. And we call ourselves Whistleblowers for Positive Change. And we've invited Judge Dennis Davis to help from his wisdom and experience of many decades, from the older regime into the transition into democracy and into the post-transition, where a type of state capture, who has been a teacher of some acclaim, never shy to be controversial, never shy to speak his mind, because he so believes in the Constitution that he had influence over in terms of the freedom of expression it allows, and he tries to exercise that with the requisite sense of responsibility, so that citizens may basically own the Constitution. And I've invited one of our members, Ngoye, to co-pilot with me so that I can continue to manage the production and all the rest. So Ngoye, over to you.
Welcome, and thank you for being here. So firstly, we're going to play a video of Judge Davis speaking to a gathering of the Social Justice Coalition in 2014. Then Martha and John will further frame the dialogue of how they landed up here. Following that, Judge Davis will respond to the three inputs, and then we will open the dialogue for members of our group to have a back and forth with Judge Davis. In closing, we will have Martha respond to the judge and pull the threads together by identifying points of concern, difference, as well as further action.
I want to refer you to what I think is a really interesting book which I've sort of been teaching at NYU, by Okamogu and Robinson, called Why Nations Fail. They ask the question, why do certain nations succeed and why do certain nations fail? One fundamental thing, which we all know, it's institutions. And they make a division between what they call extractive institutions and inclusive institutions. Extractive institutions are ones where a small group of people perpetuate the institution, capture the institutions, and in a sense prostitute the institutions, if you like, for their own vested interests. Whereas inclusive institutions are what really matter because that's where the many are included in the process of governance. But what happens with exclusive institutions is they cannot produce growth over the long run, because unless institutions are inclusive, you do not get the level of innovation, you do not get the level of growth that's sustainable over the long haul. My society was designed, meaning our society, to have a constitution which was supposed to have inclusive institutions. That's what the Constitution suggests. The answer is that they aren't. So if you're not concerned, you should be. Because let's just look at some of the institutions. Anybody around the table want to suggest to me that the police now represent an inclusive institution? And the same is true about the National Prosecuting Authority. And I'm afraid to say that the judiciary itself is under far more pressure than I had preferred it to be. And the press. There's not an institution in this country of key portion which assists in governance, which is not either under pressure or which could be classified under the Okamogu-Robinson argument as extractive. That means that somewhere along the line, groups of people have to stand up and close the gap between the formal promise of inclusive institutions and the reality of exclusive institutions. Inclusive institutions are about transformation. Exclusive institutions are about staying where we were in one bizarre way or another. And so the question is twofold. How do we develop a framework where we actually, in some substantial way, actually can unify behind a broad vision? Perhaps it is the Constitution, overwritten as it is, and on which, by the way, if you think that you're going to get the utopia through the judiciary. I'm awfully sorry to say you're not, but that's because judges across the world, I don't think that they can bear the weight of social change. I don't think that's the judicial function at large. We can create spaces, but people have to move into those spaces. So on the one hand, how do we actually proclaim active citizenship, which actually promotes the kind of vision which is in the Constitution? How do we recapture the visions that we might have had in 1994? After 2014 and after the election is over, we'll be back to the same reality, scratching our heads and saying, how on earth are we going to get out of this mess? And the only answer to that is by being active citizens and doing it ourselves. Because we should not be prisoners of a history that has now been thrust upon us. The real history is that ordinary people actually stood up. Is that unlike the 1980s, we do have a roadmap. It's called the Constitution. We should actually lay claim to it and actually ensure that it works. Not through the judiciary, that's not important, but through the kind of active citizenship which in fact is so absent and which in a sense has to a large, sad extent allowed extractive institutions to grow and the promise of inclusive institutions to be reduced. So
Good. So, Martha, please tell us your experience and give us an account of your slow suit ordeal.
Well, it's interesting that, a judge spoke about the fact that ordinary citizens, ordinary people stood up and came forward. I guess I'm one of those ordinary people because I would never have ever thought that this is where I would land up in my profession. And I am here having been a group executive of a state-owned enterprise and responsible for legal risk and compliance, which is primarily a governance-related portfolio. I find myself here because I came forward also from, the State Capture Commission's perspective. When citizens were requested to come forward and assist the State Capture Commission with evidence that they have at their disposal that would unearth the corruption that exists within the country. And just being, the professional that I've been and working for a state-owned enterprise and having experienced, the issues that I had experienced internally, I felt it was important to come through. One was just simply doing her job, and one was just trying to also be patriotic at the same time. But it didn't go well, I guess, for me at the end of the day, because I found myself having to deal with quite a lot of challenges, having to deal with the media, having to deal with my name being defamed in the media, having to deal with losing my job. In fact, I lost my job. And I had to rush to the courts to exercise my rights there. And I went to the labor court on an urgent basis where I was dismissed based on a contract that was said to have expired when I was on a full-time contract. Even though, that case, we were successful in it, we continue to wait because it's on appeal. So we'll see what the outcome of that case is. But also coupled with that, when we went back to work as per the court order, we knew part of the process would be that we would be suspended, and yes, indeed it was so. So we were given notices of intention to suspend, and we had to explain ourselves, which we did. And in no time, we were placed on precautionary suspension. And 21 months later, I'm still outside of a portfolio that I was employed to do, and trying to fight for my rights and having to deal with the charges, all sorts of charges that have been leveled against me. One of which was having appeared at the State Capture Commission, but it had since been withdrawn by my employer. So this is how I find myself here. I mean, it was not planned that this is where I would be, and have then become, an activist fighting for the rights of whistleblowers. Because as it is, we are called whistleblowers, but we remain professionals. But the reality also is that where we stand and where we sit is we find ourselves outside, isolated, nobody wanting to employ us, for reasons best known to both private and public sector. I was adopted effectively by the active citizens movement, which phoned me and said, come on board, because if it had not been for civil society, I don't think I would have survived this course.
Sure. If it had not been for civil society.
Yeah.
John, over to you.
Well, Judge, thank you so much for this opportunity. You've no idea how encouraging it was to us that you considered this worthy of your time. I'm one of 6 beneficiaries, as I think you might know, which include 3 lawyers and 2 community activists, of a defamation SLAPP suit brought by an Australian mining company, MRC, and its founder, Mark Caruso, who, together with his business partner, Zamile Ngoye, took exception to criticisms we leveled for the way they went about their business on the Wild Coast at Kolobeni and on the West Coast at Tormund. By using the word beneficiary, I'm not being sarcastic. I will explain later, but for those unfamiliar with that long-running saga, it is well documented on a playlist on my YouTube channel from the archives of the Kolobeni mining conflict, and there's a link to that playlist in the description notes below. Well, there are 66 films currently uploaded, and the most recent addition is the Concord hearing of the 22nd of February this year, in which our advocates, led by Jeff and Steve Budlander, asked the Constitutional Court to affirm the finding of Judge Patricia Goliath, the Deputy Judge President of Western Cape, that the Australian Mining Company were abusing legal process with a meritless action simply aimed at trying to silence their critics. We argued that this was a violation of our constitutional right of freedom of expression. By using the word beneficiary, I may be jumping the gun, because the playlist lacks the final judgment, which will be added as soon as it's handed down. But if you watch the Concord proceedings, I think you will agree that it is likely the judgment will not only put a smile on the face of my good wife and my family, who have had to endure a 6-year wait, but it will be beneficial to civil society as a whole in widening the space for concerted citizen action to hold both corrupted power and the corrupting money accountable. However, even if Concord opt to extend the ordeal by referring the matter back to the High Court, I believe it has already been especially beneficial to whistleblowers for 2 reasons. Well, firstly, because being slapped enabled me to have greater empathy with them and be a better social worker. Except that I now know, as Martha's story illustrates, that whistleblowers have had it much harder than me. I knew what I had signed up for when I chose social work as a career path, and I've simply been doing what my professional code of practice obliges me. I actually carry 2 booklets in my man bag. The first is a well-thumbed copy of the Professional Code of Practice, which obliges social workers as their very first duty to, and I quote, social workers challenge social injustice. Social workers pursue social change, particularly with and on behalf of vulnerable and disadvantaged individuals, families, groups, and communities. Social workers strive to ensure access to needed information, services, and resources, equality of opportunity, and, I emphasize, meaningful participation in decision-making of all people affected by adverse conditions. While the second booklet is the Constitution, because at the beginning of the Code of Conduct, we are told that social workers must do all what I've just mentioned on the basis of the Bill of Rights, which enshrines the rights of citizens which must be upheld by all. Well, I knew I'd be scrutinized and anticipated some risk of some form of retaliation. Well, and if you're intimately familiar with the mining rights saga at Kolobeni, I was simply being slapped for doing my job. But the suffering of whistleblowers is far more aggravated because they did not sign up for the retaliation of what I call a variation of the SLAPP, a slow suit, strategic litigation on whistleblowers. They are simply employees expecting to be rewarded for being especially conscientious. Instead, they found themselves served either with charges of misconduct and or trumped up criminal offenses or in some cases defamation claims, all in retaliation against them for blowing the whistle on corrupt practices, abuses of power, and unethical behavior. Well, also on my YouTube channel, there's another playlist titled The Aletheia Dialogues with Whistleblowers, and there are interviews with different whistleblowers which provide examples of each. Well, I explain in one of them exactly how we chose the word Aletheia. The second reason why whistleblowers could be beneficiaries rather than victims of the SLAPP is that there is clearly an inclusive thread that binds us all together. I emphasize could because this depends on how far the Concord pursues an inclusive approach. But the common denominator in all our stories is the weaponized use of the law against anyone speaking truth to power. Well, Judge, you will be probably familiar with the context because Judge Patricia Goliath was a colleague of yours, but the appeal arose from her judgment in which she offered us some welcome judicial lawmaking by describing exactly what was happening. And I quote, "Corporations should not be allowed to weaponize our legal system against the ordinary citizen and activists in order to intimidate and silence them. Litigation that is not aimed at vindicating legitimate rights, but is part of a broad and purposeful strategy to intimidate, distract, and silence public criticism, constitutes an improper use of the judicial process and is vexatious. SLAPP suits constitute an abuse of process and are inconsistent with our constitutional values and scheme." Without counting our chickens before they hatch, I'm reasonably confident that Concord will open up and widen the space for citizen activism and by so doing send a signal to deter further vexatious litigation in future. Well, that means citizens will have less excuse for not exercising their right to freedom of expression, to hold government, corporates, and leaders of our public institutions accountable through concerted citizen action. But time is not on our side, and watching your address 8 years ago, it occurred to me that it's not only whistleblowers and other activists who need to have a better protection from speaking truth to power. The country as a whole needs to see the extractivist stranglehold loosened. Well, we are seeing signs of hope where there are changes happening. National Lotteries Commission example. But I want to know if you're seeing enough evidence to show that we are indeed transforming from that extractivist to inclusive institutional culture. And well, if Robertson and Asmaglo are correct, South Africa is going to move from simply being a captured state to a failed state if whistleblowers continue to experience such hazardous consequences. In fact, even as I speak, I'm just seeing comments coming in from the YouTube chat from whistleblowers eagerly awaiting your thoughts, Judge. So, Judge, that explains why I found myself before you, and I will let you judge for yourself as to what to make of it all. Thank you.
Judge Davis, we are hoping you have a response for that question, how we do not move from being a captured state to being a failed state. How do we even reverse, I suppose, the impacts of state capture and find ourselves in good standing again?
Thank you. It's kind of odd to sort of listen to oneself from 8 years ago. I'd clean forgotten about that particular talk, and I suddenly began to work out where it might have been, but that's another matter. And it does strike me when John sort of said, you know, you want to comment on this. That's 8 years ago. And if you think about it, state capture has been in South African history throughout its history. The suggestion that the apartheid regime and the various racist regimes before 1948 weren't a form of state capture is, of course, ludicrous. Of course they were. Society had levels of corruption from the day zero. And I think it is true to say that if you contextualize that from 2014 onwards, in other words, when I talk, clearly by then, state capture was really underway in the modern iteration in an extraordinary fashion. And And the Zondo Commission has now sort of put that right into the spotlight, although it is fair to say that we were beneficiaries, using John's term, beneficiaries of some very courageous reporting from the media throughout this particular period, which indicated precisely, to some extent, the extent of this pathology. Now, in answer directly to your question, I think we are at an inflection point now in the year 2022. That's certainly 8 years after I was trying to utilize Robinson Aglemoglu's analysis about inclusive states, meaning we really do have a choice now. Do we actually move towards embracing in a far more fulsome way than we've done in the last decade a system of accountability, transparency, and integrity, which are central values of the constitutional structure which we sought to introduce back in 1994 at the time of democracy, in 96 when the final constitution was passed? Or do we actually continue to use the law as it has been in order to promote rent-seeking, further state capture, and, in a sense, immunization of those people who've basically not wasted, but stolen precious state resources, which could have been used for the reconstruction of society? And when listening to all of you, particularly Marja's point, my heart goes out to you because, you know, in a way, you represent the kind of citizen who encapsulates the values of the Constitution in a manner where you've put your money where your mouth is, as it were, by asserting the principles of integrity, accountability, and transparency to your great cost. And the only way that we can, as it were, prevent that inflection point, meaning that we descend into greater levels of state capture and rent-seeking, is to ensure a greater empowerment of citizenry and civil society as a whole. That is to build on that which we've got. Obviously, that does require amendments to the legislation which protects whistleblowers, but it does more than that. It's the question of to what extent we're going to have a civil society which says, actually, whatever its imperfections, this constitutional democracy is the best we've got at the moment, and we need to protect it. And what that means ultimately is ensuring that we guard against the manner of just literally people being intimidated into silence or alternatively being bought off. Because here's the thing. If you think about the level of state capture and the resources that have literally been channeled into certain people's hands, it's probably true that something like 6 million children may well go to bed every night, either starving or certainly on the margins. And one wants to ask the question rhetorically, certainly I do I really want to live in a society where so many children are suffering in this particular fashion? Or do I want to live in a society where we harness all the resources of the society to ensure that those children and their families actually can live a dignified life? It is extraordinary to me, that in the name of so-called transformation, or even radical transformation, as the term is used, we find the justifications for increasing levels of rent-seeking and state capture. And rather than, in a sense, the transformation of society to one based on the constitutional vision of equality, dignity, and freedom for all. Let me just end my remark by saying, perhaps 8 years after I made those remarks that were recorded, there are a couple of green shoots. I think it's terribly important that there's been a really significant outpouring of civil society protest against intimidation, certainly of certain whistleblowers. I also think it's terribly encouraging that the National Prosecuting Authority is holding more and more people accountable. And as Andrea Johnson said this morning, she's the head of the SIU, that in fact they just got started after, in her reaction to the arrest of Mr. Koko. And I can only hope that essentially an aggressively implementing National Prosecuting Authority, South African Revenue Service, which is also being turned around, and hopefully at some point the Public Protector's Office, which sadly has been captured, But if we can turn that around to what it was when Advocate Modonsela was the public protector, we've then got institutions which underpin the particular work that whistleblowers are doing courageously, which is to hold people accountable to some level of dignity, transparency, and honesty. And so I'm not entirely despondent, even though we're at an inflection point. There do seem to me indications of sections of our society that have said enough's enough, and we don't want 6 million children to go starving every night. And we do want to have a society which embraces the values of the Constitution in the fulsome way. And so I think we need to empower those institutions. We need to empower whistleblowers. We need to empower civil society to continue that particular work, and to sort of basically say, well, state capture sought to engulf us and threaten the very promise of freedom. It didn't entirely succeed. Judge Zondo has explicated that and has forced a level of accountability which we need to extend into every level of society.
I do honestly feel a bit encouraged, actually, now that you've pointed out the level of change that has happened, or at least a shift towards change. Now we are going to have a Q&A session.
I've got so many questions I would love to ask you, Judge. And also just to honor you, because interestingly, going back to my experience with the Korobeni mining, you wrote an article in 2008 in International Human Rights Day in which you talked about the Constitution as being more than mere text. And that was so inspiring to me because it confirmed that my work as a social worker, that I was on the right track in support of the Amadiba community to assert their right to free, prior and informed consent. And the mining rights were actually revoked without going to court first time around. But I guess if I hadn't had your influence, I would have thought, well, okay, we're going to give up. The state's just too powerful and start looking to pack for Perth. But I stayed because I thought, when I looked at what the Australian Constitution looks like, it wasn't particularly as permissive and encouraging as ours. So I thought, well, hang on. And the particular important thing is that I was talking to a Sangoma right at the beginning of my involvement, and I asked him, I said, what do you see the future of what's happening here? And he said, we will go to war if the mining takes place. And I said, you don't need to go to war, you just need to go to court. And ultimately, we did go to court, and they did win. So I'm just mentioning that partly just to encourage us all, because there were very dark moments back then. The concern I have is that human rights have been owned by civil society, by whistleblowers. But we have politicians and judges and everyone swear an oath of office to uphold them. Yet we see it being paid mere lip service to it, and it really concerns me that the extractive nature of our society and our institutions is still too tightly held. And where can we find points where we can loosen the grip and that stranglehold of that tendency for power to simply abuse and use any instruments, defamation and SLAPP suits, what have you?
Yeah, it's a great question. There's part of it, of course, which is the question, I think your anxiety is the way in which courts are used to silence people. And of course, to some extent, that's what my colleague Michelle Leroux and I were talking about when we wrote our book on lawfare, the way in which the law is used. And the law can be used in a good way, in other words, to promote the kind of values you're talking about, but it can also be used in the way to silence people. That is a problem. And certainly in the broad sense of the word, courts have to be very vigilant about this. It'd be interesting what that judgment of the Constitutional Court does hold in this particular regard. Courts also have to be vigilant in relation to the way in which law is abused by people to subvert the very values of the Constitution in the first place. But I think the second part of my answer to you, which is the political answer, is that I do think, despite all the bleakness and the fact that I too feel that to some considerable extent there's an extractive component in our society, which basically has, as I've indicated in my introductory remarks, which seems to suggest that that we are entitled, we, a certain elite, are entitled to capture the rents of society at the expense of the vast majority of people. That particular impetus has run into, I think, more resistance than perhaps we would have thought possible at the darkest times of state capture. It's run into resistance through media. It's run into resistance by the kind of discussion we're having today. It's run into resistance by certain litigation. And it does seem to me it's run into resistance because the Zondo Commission has essentially opened up a can of worms, which are going to be very, very difficult simply to ignore. But my own view always has been that it's not so much through litigation that one wins the day. It's through active citizenry. And the example I always use, which I think was a remarkable example, was the ability of the Treatment Action Campaign back in the day when they campaigned for antiretroviral drugs to be made available to all those people living with HIV/AIDS. And although they did use the court mechanisms in famous cases, which culminated in a victory in the Constitutional Court, it's also true that they managed to shame the pharmaceutical companies to such an extent that the pharmaceutical companies could not resist the campaign, and eventually generic antiretrovirals were made available at a reasonable price so that people could actually get the necessary medication. And so what I want to really say to you is it's exactly the kind of initiatives that you're having this morning, which become particularly important. And what we need to do is to counter a whole range of perverted discourse, which seeks to suggest that those of us who sort of asserting principles of accountability, transparency, and whistleblowers who are here and who basically get ostracized, that they're the heroes, and that in fact we need to basically acknowledge them as being central heroes in the constitutional struggle, as opposed to those people where it's couched as, oh, you just all kind of reactionaries. So it's a real question of the reconstruction of our public discourse as to assert the very principles we're talking about this morning. Unless you do that, I don't think courts in the long run protect you. In short, constitutions don't lift themselves unaided into legality. They do so because the population of the country considers them to be so important that not even politicians are prepared to tamper with them to a large degree. And when whistleblowers are ostracized in this way, we need greater outrage to protect them and to ensure that, in fact, they are not ostracized, but in fact, basically acknowledged and rewarded for the heroic work they do. And if you don't have that level of active citizenship, then you're in big trouble. And the fact that we're sitting here this morning indicates the potential for that very active citizenship.
I agree, because, I mean, having experienced and having gone through the challenges that I've gone through as a whistleblower, and also, Judge, for me, the issue is also around the abuse of state resources in fighting whistleblowers. I mean, at the end of the day, as whistleblowers, it is about holding people to account. It is about making sure that people do not abuse state resources. But at the end of the day, it is the state resources that are then also used against the whistleblowers. I mean, in my specific case, it was made clear that I need to be fined so that I can fight the state outside, and I'll never be able to afford it because the might of the state will be huger than I am. And I've experienced that, and I've spoken about it throughout, and my story has always been that I would never have incurred the amount of legal bills and the debt that I have currently if the people that were persecuting had to use their own resources to do so. It would never have happened. But because they are using state resources, it's very easy. But also for me, the concern has been what has happened to the various professions that are out there. You have lawyers and accountants and everybody out there who have an appreciation that actually what is happening is wrong, and they don't have the law on their side, but they continue to do it and they get paid out of, the injustices that have been created where whistleblowers are concerned. And that's why I say, for me, had it not been for civil society, and civil society has been very vocal about protecting the whistleblowers and the need to protect the whistleblowers, even though not much has been done. It's just been lip service, really, at the end of the day. But I agree with you, unless there is that outrage and serious outrage, from civil society to say the whistleblowers must be protected, people are not going to go ahead and hold people accountable, because it has not been an easy process. I don't wish anybody to go through what one has gone through. And the issue is that it does not only affect me as an individual, it's affected my family as well. It's affected my health. Whistleblowers have to be there, but at what cost? When they are going to be left alone. And civil society really has been important in this regard. And my thing is, in certain cases, take for instance the labor appeal case. We won our court case, and we were reinstated. And the organization applied for leave to appeal. They lost, and they petitioned, and they got the leave to appeal. I look at it and I say, perhaps I don't understand how it works. And I dare say that, having been a scholar of the legal process, just dumbfounding. But at the end of the day, it's costly, and also in terms of having to fix the legislation, how long it's going to take. And that's why I was saying the other day, the legislation may be fixed, but what happens to the whistleblowers of today? What happens to the whistleblowers of today?
Are we not trying to treat the symptoms as opposed to treat the root cause? Is this level of greed and extractivism not a function of capitalism?
Well, the answer to that is in part yes, of course. But I mean, and that, of course, is a much larger topic. In a way, our constitution envisaged much more a social democratic form of state, in which the private sector obviously played a very important role, but so did the state. And the fact is that what has happened in our society is a twofold problem. Number one has been a state that has not been capable and therefore not been able to perform its social democratic functions to the extent that it should. And some areas of the private sector which have exploited those gaps shamefully. In the broad sense of the word, you're right. Global capitalism has created considerable havoc, but it's also true, it does seem to me, that again, the world is at an inflection point in regard to that, because clearly levels of inequality and poverty are now very central to not just to South Africa, but to the global world. And so your broader point, which of course is perhaps beyond the scope of this particular debate, but is vital, is the extent to which the kind of model that we sought to embrace, where the state has a greater role and where unbridled forms of capitalism don't just go rampant, that we need to kind of rethink what kind of global system we want. I think one good point about this is the idea of a libertarian notion where the state totally withdraws, allowing capital to run rampant, has run into fantastically difficult circumstances, and we need to thank Liz Truss for that, because I think libertarians are not going to be able to show their face with a great deal of ease. So I do feel your point is an important one, but I do think that if we were showing a greater fidelity to the model of the constitution that we had, at least to some extent, those rapacious consequences would have been tempered far more than they have been up till now.
Some comments that are coming through on the YouTube stream and the chat. Angelo Grizzi talks about the media. Do the media offer a safe harbor for whistleblowers? If I may just say, part of my entry into this whole process was to support a whistleblower who wasn't in South Africa, who was overseas, and because he wasn't easily got at through any physical threat, he was basically mercilessly retaliated against in the media. So the media we think of as a safe harbor for whistleblower. To what extent has the the harbour silted up and leaving some whistleblowers like beached whales, going back to the extractive and inclusive thing. I cannot conceive of us moving back towards inclusivity if we were ever there, but we, at least in theory, we were there, without a redoubling of effort within our media space for truth to matter.
Well, yeah, I mean, the trouble about it is that you're never going to get one particular, the fact that truth matters is itself a contested concept. But you did right. There is an obligation on media to perhaps present a more accurate picture. The real problem is that every single person views the world from a particular set of ideological lenses, so that's often difficult to say you're ever going to get totally, the sort of idea that the BBC 50 years ago was a totally objective organization, there was none other. It seems to me that what is required is, in a sense, to encourage as fearless a reporting as possible. And once you've got a broader choice of media, something emerges out of that, because I'm not sure you'll ever get one publication which meticulously just records. On the Greetsy point, which you mentioned, I agree that to some extent the media may have been unfair to him, but let's be honest about it, it's a very complex case. His whistleblowing is entirely different from some of the other people who suffered, in the sense that, he himself admits that he was deeply implicated in what was going on in the organization. And so you can't blame media for not highlighting that.
Moving to the close, I see Selo Trino's just joined us, and I don't know if you want to say something, Selo, but maybe just to give you a background to him, because this is a very good news story. Well, hopefully, still a good news story. Selo and another one of our members, Mzum Katse, were working for the National Lotteries Commission, and they refused to take orders that would have resulted in wrongdoing and compounded further wrongdoing. And both of them ended up basically being slowed. Strategic litigation on whistleblowers, weaponized use of disciplinary procedures to kick them out. However, Ray Joseph, and this is credit again to the media, doggedly would not let go of this, despite himself getting what I now call another version of the SLAPP called a SLAM, strategic litigation against media. And he was able to fend off that thing, and he's busy writing his book about it. And it's wonderful to hear the Constitution coming into fruition here again, Dennis. Your thoughts about how the National Lotteries Commission can now become even more inclusive. It's now chaired by Barney Pichana. Isn't that marvelous? Somebody who was the chair of the Human Rights Commission, with whom you've had a bit of a history. Isn't it wonderful that we can now look? And I think you were recommended him as one of the people to come on to that. Do you want to give some comment to those of us who are still waiting, not wanting to get our hopes up too quickly, that there will be a sudden switch where these extractive institutions will suddenly become inclusive of whistleblowers, re-employ them, give them jobs, and make sure that their credibility and legitimacy is restored?
Well, I think it's a very important point. Firstly, I have a great deal of confidence that Barney Pichana is the chair. Certainly, I had no hesitation in recommending him. Will do a splendid job in restoring the credibility of the Lotteries Commission, period. Given his history and given his commitment to accountability, I have no doubt that will be true. It does show you something which is also interesting, is that Minister Patel should be given credit. Minister Patel realized quite some while back that there was a massive problem with the lotteries, and that there were all sorts of allegations, and more than just allegations, of impropriety, and did something about it. And it's very interesting in regard to the earlier conversation we've had, the obstacles which were placed in the way of Minister Patel by those who, in a sense, were beneficiaries of the process, using the law in order to basically attempt to prevent Minister Patel from effecting changes to the lottery structure, which would have ensured that the lottery, that the money from the lottery actually goes to where it is intended to go. So it does show you a number of things. It shows you, one, that the kind of publicity, and I think Ground Up, the online newspaper, needs enormous credit for this, they exposed a lot of this. The second part was that's exposed because there were people within the lotteries community and commission who were courageous enough to ensure that this got into the public domain. 3, that we had a minister who was sufficiently aware and committed to a different form of lottery scheme and therefore sought to change the process. And 4, the way in which, even when that occurs, people, as I've indicated earlier, use the law to prevent the kind of meaningful change from taking place. But at the end of the day, it's precisely that point that is to have a group of people running the show with considerable integrity that will change the process. And it is true that when the president suggested in his response to the Zondo Commission that there'd be a greater level of transparency in regard to all these appointments, that's something that should be encouraged and he should be held accountable to, meaning I'm not suggesting he's not going to fulfill his promise, but the promise needs to be implemented, because it's then when you get people like Dr. Pityana in that you start seeing the sort of changes which I suspect we will see very shortly in the lottery situation.
Martha, you're going to try and pull the threads together for us.
Well, I think I don't know if I have to, because I think it's been very clear, you know, from what Judge has been saying, you know, in terms of the role of the whistleblowers, the importance of civil society, and the need to hold people accountable. The fact that our constitution does exist, and we rely on civil society to make sure that we ensure that there are constitutions and what is enshrined in there, and as far as the Bill of Rights and so on are concerned, are not eroded. What I like is what Judge, you've just said now about the people who are right at the top having considerable integrity themselves. And wanting change, because unless you have that at the top, change is not going to happen. That is very critical, because what seems to be happening now is that the people that are there are not necessarily acting in the best interest of the state. Really, it's in the best interest of themselves, and we see, you know, from the various arrests that have happened in the recent days. We still have a long way to go. There is a need still to have whistleblowers encouraged to come forward and to be supported. And the outrage must just be there and must never stop, you know, because unless it is very visible, whistleblowers will never go protected. That's it from me.
When you're talking about change at the top, is the fact that something we spoke about yesterday, John, which is that government essentially is not independent, or the 3 pillars of state, the judiciary, the executive, and the legislature, are not actually independent, because the majority of the people that are appointed there are appointed by the governing or ruling party, which is the ANC, and there is an expectation for everyone to vote along party lines. Likewise with appointments to senior management levels in state-owned entities and organs of state, those appointments do not necessarily happen independently, because those people are deployed into those positions, which creates an ample amount of complications, especially in the event that they are not actually qualified to be in those positions.
Judge, do you want to comment on that, the issue of deployment, before I wrap up?
Well, my understanding was that apparently even the cabinet has now basically takes our view on that. Now that shouldn't occur. So hopefully they will implement. I mean, at the end of the day, a country like South Africa now requires 2 basically imperatives. Obviously, we need a society which transforms the entire range of positions to broadly reflect the demography of our country. That's obvious. But the second aspect is that what saddens me is that the talent which would allow us to promote that level of transformation is not only exclusively, in fact, to the contrary, is not exclusively within the, as it were, domain of the ruling party. There are literally thousands and thousands of unbelievably skilled people, talented people of great integrity outside of that particular small population. And why on earth we aren't using them in a society where the imperative now is to ensure that we construct a society that works for 60-odd million people is what we should be demanding. And if the cabinet is committed to that, well, then I can only say bravo.
Okay, well then just closing, I want to just, in giving thanks and gratitude to you, Judge, because I had this rather nasty saying about lawyers. You know, they say that, the problem with lawyers is just that 95% of them give all the rest a bad name. Now, the funny thing is, I have been so privileged to work with that 5% of lawyers that redeem the profession. And it doesn't take very many to actually kind of have the positive influence. And I've discovered that when I was telling them that I had the privilege of interviewing you, they were all students of yours. Yes. One of whom said to me, you came out of having delivered a judgment on some matter that was particularly contentious and difficult, but very much raised issues that were a bit murky in terms of what the law and the Constitution could say. I don't know what it was. You came into the class and you said, look, I don't know whether this is going to be considered legal enough, but I just had to do something. Now, I'm sharing that with you because you inspired that law student. She's now gone on to be doing some extraordinarily good work as a lawyer in society at large. So thank you for that, and come back to South Africa and help us in the struggle. And
yeah, I'm just here for a day or two, but thank you very much, and thank you for inviting me.
Other person who had a huge influence on me was Mary Robinson on my work in the Kolobeni mining thing. In 2007, at the beginning of where I was getting involved, I was invited with Richard Spoor to a business and human rights conference, and she happened to be there, and I found myself sitting next to her, and we had a couple of conversations which actually gave me such an encouragement. So the two people that have been like the bookends of my work have been two lawyers. This is basically what she said. Human rights do not belong to government.
One of the problems with the Universal Declaration, as I mentioned, is that yes, people refer to it and it has been much translated thanks to the work done for the 50th anniversary, but actually we don't take it personally. We think it's something that governments should bother about. But if you read the first words of it, it becomes very personal. And I think that's the difference. If we can try to ensure that perhaps 1 billion people, which is what the elders want, will pledge to make the Universal Declaration, personal in our lives. So she thought we'd have it in our pocket, take it out every day, think about it, and apply it in our school, in our community, in our workplace, in our home, university, and beyond the university. And I'm going to end with Eleanor Roosevelt's words because I invoke her all the time. You remember she said that if human rights are to matter at all, they must matter in small places close to home, so small that you cannot find them on any maps of the world. But they are the world of the individual worker in his factory, in his farm, etc. And she said that the way in which this would be done would be by concerted citizen action, by people holding their governments accountable. And I would say that that is the essence of really trying to make the case that human rights don't belong to governments. They're the birthright of every one of us, the 6.7 million people in the world, and it will go up to, a billion rather, and it will go up to 9 billion by 2050. So we have a crowded world that needs to live in harmony and to think. And I think that the way I would sort of build a bit on what Eleanor Roosevelt said is not only must it be part of concerted citizen action, but human rights must also be there in the context of government decisions, implementing the commitments they've made, and in the boardrooms of large corporations. And we need that partnership that is 21st century, that it's multi-stakeholder to achieve what we have woefully not achieved up to now. So, but we shouldn't underestimate the fact that we have an awful lot to do if human rights are going to matter in small places close to home. So thank you very much for being such a wonderful audience. Thank you.